of course, coming into question is the signing of indemnity forms at the moment. So let's talk about that. And those are the forms that parents sign before children actually do go on school trips. Now, do they absolve the school of any wrongdoing in cases like this? Let's go to Cape Town, where we'll chat to attorney Mary-Faith Saku. Mary-Faith, a very good evening to you, and thanks for your time. So yes, I suppose this question was bound to come up. Shouldn't parents sign an indemnity form? Can you hold the school responsible for an incident like this?
Thank you. Thank you for having me. So indemnity form in itself does not necessarily absolve the school from responsibility. It was going to largely depend on, firstly, the content of the indemnity form in terms of what events. Normally, we do specify the certain events that are excluded, because the indemnity serves to limit the liability. So normally, the events that are excluded or that are limited are specified. So it will depend on what is in the indemnity form, and then also what transpired. If there's negligence or gross negligence, then the indemnity wouldn't afford the school any protection.
Well, I would imagine, Mary-Faith, that, as a parent myself, when a school asks me to sign an indemnity form, it's if my child stubs his toe during the trip, if my daughter gets cut or gets hurt during a trip. But in a case like this, where we have the most horrific thing happening to a child and the loss of life, surely, parts of that agreement between parent and school become null and void.
It's difficult to say with any definite at this point, because we don't have all the facts of what happened there. But generally, excuse me, accidents do happen. And until such time as you can actually say that what happened to that boy at that school was as a result of somebody's action or inaction or negligence, then only can you actually have a look at whether the school can rely on the indemnity. Because as you say, the child can stub their toe or something, and you wouldn't necessarily want to hold somebody liable, because kids are kids and accidents do happen. So the question of whether the indemnity will hold up and whether it's going to be valid or it's going to be null, it really depends on what exactly happened that led to ENOCH's unfortunate death.
Well, in this particular case, you have to wonder, what we know so far is even the MEC saying the kids were on a river where there was a particularly strong current because of recent rains, that there doesn't seem to have been a life jacket anywhere in sight. Should not every group of those kids have been watched by someone, that someone would have seen ENOCH go under the water? So those questions, I would imagine, would be pertinent to determining accountability and whether there was negligence as well.
Yeah, absolutely. There are a lot of questions that actually need to be answered in order for an assessment to be made as to who can be held accountable. The life jacket situation being one of it. Were there life jackets? How many people were looking after the children? Did they have adult supervision? Did they have somebody who can swim, who can rescue them, lifeguards, and so forth? And so it's hence I said earlier that until such time as all the facts have come out, will we then know at whose door can we put this, and where can we start to say who was negligent, who did not. They have a duty to look after the children in their care. Who did not fulfill this duty? Who failed these children in that moment?
And what we also know for a fact, Mary-Faith, is that, he was only reported missing the very next day. This happened on Wednesday. The very next day, how do you not know for all that time that one of your pupils is missing and then reporting it? So that as well is just so bizarre in this case.
It's certainly very concerning, and it speaks to the issue of the duty of care and the duty of protecting these children and safeguarding their well-being. If a child is entrusted in your care, you are obliged by law in terms of the Children's Act to ensure that child's well-being. So it does raise the question of what the caretaker, if I can call them that, how did they not notice that the child was gone? Were they actually exercising their duty of care properly and diligently in order to know that, okay, the child didn't come back out of the river, let's go look for him? It does certainly raise a lot of questions, and it's extremely concerning.
Okay, so it just depends on the wording of that indemnity form, if I understand you correctly, and then, of course, all of these questions, whether there was negligence, might, in the end, depending on the investigation, render this null and void, if that was the case.
Absolutely, absolutely. The facts, once they've been once the report is out as to what exactly transpired, that will help us to see whether the indemnity will hold and also what the indemnity says. But as I said earlier, you cannot contract out of negligence. You certainly cannot contract out of gross negligence. And if there was negligence on behalf of the people looking after the children, then the indemnity wouldn't be much help of much use to them.
All right, thanks very much for that. And that's Mary-Faith Saku. She's from Saku Attorneys, just explaining to us just the validity of an indemnity form in a tragedy like this. And unfortunately, the investigation is still underway, and no one at the moment can be held accountable for it.